I had a question from a potential client that I've never heard before, and the question was, do I need to refinance the house before we begin our estate plan? Do we need to get the refinance done before we start our estate planning? My name is Philip Bruce. I'm an estate planning attorney here in Minnesota, and I believe I know where this question is coming from. There may be some deed work associated with an estate plan. Do we want to get the refinance out of the way? And the answer is almost never no. It doesn't matter, because here's what we're looking to do. When you refinance the house, you're not changing your title. The title of your house is staying the same when you refinance. The mortgage, the thing that's secured, that the house is securing, that's going to get refiled, but the ownership in the house is not going to change. If we're doing a will plan, there's nothing we do with real estate deeds typically, so do whatever you want to do with the house. It doesn't matter. What a will is a set of instructions for after death. Ownership of the house, deeds, etc., none of that stuff changes until after someone dies. It's instructions for the probate court system. So wills don't come into play until after death. There's another type of plan, we talk about it all the time in these videos, a revocable trust or a living trust. And if we're doing one of these types of plans, then yes, we're going to do a real estate deed. But here's the thing, it still shouldn't matter. If we're doing a joint revocable trust, we're going to do something called a transfer on death deed. This is a special deed that's filed with the county that says, if I die, where does it go next? They're great as long as you're naming one person or entity. If you have 3 kids, you would almost certainly not do a transfer on death deed. If you have one revocable trust, one family entity that avoids probate, yes, you would name this thing as receiving the transfer, receiving the house via the transfer on death deed. Perfect. Nice thing about the transfer on death deed, it doesn't change ownership at all, so the bank doesn't even have to know about it. The mortgage company doesn't even have to know about it. You can do this anytime at all. The exception to this is when someone is of a certain age, we will recommend that they actually take the house out of their name and put the trust's name on it. In that case, we can still deal with the refinance. Go ahead and do the refinance, and we'll just delay filing this real estate deed until that's done. Get the process started with estate planning. You will stall out. If you are thinking of getting it done, you got to do it. You'll stall out, you'll put something else in front of it, and you'll just never get around to it. If you have any momentum to get your plan done, I definitely say do it. And your attorney can accommodate that refinance process after the fact. It's very easy to do. So don't prioritize one or the other. If there's one that's more of a priority to you, yeah, sure, do it. But don't let one stop you from doing the other. Any questions about this or anything else, shoot us an email.